Introduction. As about the given document describes about arrangement of sections, like chapter 1 tells about introduction, then preamble, and sections are as follows, like section 1 about title and extent of operation of the code. Section 2 tells about the punishment of offences committed within India. Section 3 tells about punishment of offences committed beyond, but which by law may be tried within India. Section 4 tells about the extension of code to extraterritorial offences. Section 5 tells about certain law not to be affected by this act. Then chapter 2, general explanations. Section 6 tells about definitions in the code to be understood subject to exceptions. Section 7 tells about sense of exceptions once explained. Section 8 tells about gender, 9 about number, 10 man, woman, 11 person, 12 public, 13 was omitted, 14 about servant of government, 15 was repealed, 16 was also repealed, 17 tells about government, 18 about India, 19 about judge, 20 about court of justice, 21 about public servants, 22 about movable property, 23 about wrongful gain, wrongful loss, gaining wrongfully or losing wrongfully, 24 about dishonestly, 25 about fraudulently, 26 about reason to believe, 27 about property in possession of wife, clerk or servant, 28 about counterfeit, 29 about documents, 29 tells about electronic records, 30 about valuable security, 31 about a will, 32 about words referring to acts include illegal omissions, 33 about act omissions, 34 about acts done by several persons in furtherance of common intention. Section 35 about when such an act is criminal by reason of its being done with a criminal knowledge of intention. Section 36 about effect caused partially by act and partially by omission. 37 refers about cooperation by doing one of several acts constituting an offense. Section 38 tells about persons concerned in criminal acts may be guilty of different offences. 39 tells about vulnerability. 40 about offences. 41 about special law. 42 about local law. 43 tells about illegal, legally bound to do. 44 about injury. 45 about life. 46 tells about death. 47 about animal. 48 about vessel. 49 about year, month. 50 about section. 51 about oath, 52 about good faith, 52a about harbor. Chapter 3 of punishment, 53 tells about punishments, 53(1) matlab A about construction of reference to transportation, 54 about commutation of sentence of death, 55 about commutation of sentence of imprisonment for life, 55a about definition of appropriate government. 56 was repealed. 57 tells about fractions of terms of punishment. 58 was repealed. 59 was repealed. 60 tells about sentence may be, in certain case of imprisonment, wholly or partially, rigorous or simple. 61 was repealed. 62 was repealed. 63 tells about amount of fine. 64 about sentence of imprisonment for non-payment of fine. 65 limit to imprisonment for non-payment of fine when imprisonment and fine awardable. 66 about description of imprisonment for non-payment of fine. 67 tells about imprisonment for non-payment of fine when offence punishable with fine only. 68 about imprisonment to terminate on payment of fine. 69 on termination of imprisonment on payment of proportional part of fine. 70 tells about fine liable within 6 years of during imprisonment, death not to discharge property from liability. 71 tells about limit of punishment of offense made up of several offenses. 72 about punishment of person guilty of one of several offenses. The judgment stating that it's doubtful of which. 73 tells about solitary confinements. 74 about limit of solitary confinements. 75 tells about enhanced punishment for certain offenses under chapter 12 or chapter 17 after previous conviction. Chapter 4 tells about general exceptions. 76 act done by a person bound or by mistake of fact believing himself bound by law. 77 tells about act of judge when acting judicially. 78 tells about act done pursuant of the judgment or order of court. 79 tells about act done by a person justified or by mistake of fact believing himself justified by law. 80 tells about accident in doing an unlawful act. Accident in doing a lawful act. 81 tells about act likely to cause harm but done within criminal intent and to prevent other harm. Section 82 refers about act of a child under 7 years of age. 83 about act of a child above 7 and under 12 of immature understanding. 84 tells about act of a person of unsound mind. 85 about act of a person incapable of judgment by reason of intoxication, caused against his will. 86 about offense requiring a particular intent or knowledge committed by one who is intoxicated. 87 tells about act not intended and not known to be likely to cause death or grievous hurt done by consent. 88 tells about act not intended to cause death done by consent in good faith for person's benefit. 89 tells about act done in good faith for benefit of child or innocent person by or by consent of guardian, providers. 90 tells about consent known to be given under fear or misconception, consent of innocent person, consent of child. Section 91 tells about the exclusion of acts which are offenses independently or harm causes. Section 92 tells about act done in good faith for benefit of a person without consent, provisions. Section 93 tells about communication made in good faith. Section 94 about act to which a person is compelled by threats. Section 95 tells about act causing slight harm of the right of private defense. Section 96 tells about things done in private defense. 97 tells about right of private defense of the body and of property. Section 98 tells about right of private defense against the act of a person of unsound mind, etc. Section 99 tells about act against which there is no right of private defense, extent to which the right may be exercised. Section 100 tells about when the right of private defense of the body extends to causing death. Section 101 tells when such right extends to causing any harm other than death. Section 102 tells about commencement and continuance of the right of private defense of the body. Section 103 tells when the right of private defense of property extends to causing death. Section 104 tells when such right extends to causing any harm other than death. Section 105 tells commencement and continuance of the right of private defense of property. Section 106 tells right of private defense against deadly assault when there is risk of harm to innocent person. Chapter 5 of abatement, like Section 107 tells abatement of a thing. Section 108 tells abater. Section 108a abatement, an Indian of offences outside India. Section 109 tells punishment of abatement if the act abated is committed in consequence and when no express provisions is made for its punishment. Section 110 tells punishment of abatement if person abated does act with different intentions from that of abater. Section 111 tells about liability of abater when one act abated and different act done. Section 112 tells abater when liable to cumulative punishment for act abated and for act done. Section 113 tells liability of abater for an effect caused by the act abated different from that intended by the abater. Section 114 tells abater present when offence is committed. Section 115 abatement of offence punishable with death or imprisonment for life if offence not committed. If act causing harm be done in consequences. Section 116 abatement of offence punishable with imprisonment if offence be not committed. If abater or person abated be a public servant whose duty is to prevent offence. Section 117 abating commission of offence by the public or by more than 10 persons. Section 118 concealing design to commit offence punishable with death or imprisonment for life if offence be committed, if offence be not committed. Section 119 public servant concealing design to commit offence which it is his duty to prevent if offence be committed, if offence be punishable with death, etc., if offence be not committed. Section 120 tells concealing design to commit offence punishable with imprisonment if offence be committed, if offence be not committed. Chapter 5 tells about criminal conspiracy, like sections 120a, definition of criminal conspiracy. Section 120b tells punishment of criminal conspiracy. Chapter 6 of offences against the state, like 121, waging or attempting to wage war or abetting waging of war against the government of India. Section 121a tells about conspiracy to commit offences punishable by Section 121. Section 122 refers about collecting arms, etc., with intention of waging war against the government of India. Section 123 tells about concealing with intent to facilitate design to wage war. Section 124 about assaulting president, governor, etc., with intent to compel or restrain the exercise of any lawful power. Section 124a about sedition. Section 125 tells about waging war against any Asiatic power in alliance with the government of India. Section 126 tells about committing depredation of territories of power at peace with the government of India. Section 127 tells about the receiving property taken by war or depredation mentioned in Section 125 and 126. Section 128 tells about public servant voluntarily allowing prisoners of state or war to escape. Section 129 public servant negligently suffering such prisoners to escape. Section 130 tells about aiding escape of rescuing or harboring such prisoners. Chapter 7 of offences relating to the Army, Navy and Air Force. Section 131 tells about abating mutiny or attempting to seduce a soldier, sailor or airman from his duty. Section 132 tells about abatement of mutiny if mutiny is committed in consequence thereof. Section 133 tells about abatement of assault by soldier, sailor or airman on his superior officer when in execution of his office. Section 134 tells about abatement of such assault if the assault is committed. Section 135 tells about abatement of desertion of soldier sailor, or airman. Section 136 tells about harboring deserter. Section 137 refers about deserter concealed on board merchant vessel through negligence of master. Section 138 refers about abatement of act of insubordination by soldier, sailor, or airman. Section 138A was repealed. Section 139 tells about persons subject to certain acts. Section 140 tells about wearing, grab, or carrying token used by soldier, sailor, or airman. Chapter 8 of offences against the public tranquility. Section 141 tells about unlawful assembly. 142 refers about being member of unlawful assembly. 143 refers about punishment. 144 refers about joining unlawful assembly armed with deadly weapon. Section 145 refers about joining or continuing in unlawful assembly, knowing it has been commanded to disperse. Section 146 refers about writing. 147 about punishment for writing. 148 refers about writing armed with deadly weapons. Section 149 refers about every member of unlawful assembly guilty of offence committed in prosecution of common object. Section 150 refers about hiring or convincing at hiring of person to join unlawful assembly. Section 151 refers about knowingly joining or continuing in assembly of 5 or more persons after it has been commanded to disperse. Section 152 refers about assaulting or obstructing public servants when suppressing riots, etc. Section 153 refers about wantonly giving provocation with intent to cause riot, if rioting be committed, if not committed. Section 153A refers about promoting enmity between different groups on ground of religion, race, place of birth, residence, language, etc., and doing act prejudicial to maintenance of harmony, offence committed in place of worship, etc. Section 153A refers about punishment for knowingly carrying arms in any procession or organizing or holding or taking part in any mass drill or mass training with arms. Section 153B tells about imputation, assertions prejudicial to national integration. Section 154 refers about owner or occupier of land on which an unlawful assembly is held. Section 155 refers about liability of person for whose benefit right is committed. Section 156 refers about liability of agent of owner or occupier for whose benefit right is committed. Section 157 refers about harboring person hired for an unlawful assembly. Section 158 refers about being hired to take part in an unlawful assembly or riot or to go armed. Section 159 refers about affray. Section 160 refers about punishment for committing affray. Chapter 9 of offence by or relating to public services. So, Chapter 9 refers about of offences by or relating to public servants. Section 161 was repealed. Section 162 was repealed. Section 163 was repealed. Section 164 is also repealed. 165 is repealed. 165A is repealed. 166 refers that public servant disobeying law with intent to cause injury to any person. 166A refers about public servant disobeying directions under law. Section 166B refers about punishment for non-treatment of victim. Section 167 refers about public servant framing an incorrect document with intent to cause injury. Section 168 refers about public servants unlawfully engaging in trade. 169 refers about public servant unlawfully buying or bidding for property. So, if they are bidding for property unlawfully or buying it unlawfully, then 161 will be applied. Section 170 refers about personating a public servant. 171 refers about wearing grab or carrying token used by public servants with fraudulent intent. Chapter 9(a) refers about offences relating to elections. 171A refers about candidate electoral right defined. 171B refers about bribery. 171C refers about undue influence at elections. 171D refers about personation at election. 171E refers about punishment for bribery. 171F refers about punishment for undue influence or personation at an election. Section 171G refers about false statement in connection with an election. 171G refers about illegal payments in connection with an election. Section 171I refers about failure to keep election accounts. Chapter 10 refers about contempt of the lawful authority of public servants. Section 172 refers about absconding to avoid service of summons of other proceedings. Section 173 refers about preventing service of summons or other proceedings or preventing publications thereof. Section 174 refers about non-attendance in obedience to an order from public servants. Chapter 174A refers about non-appearance in response to a proclamation under Section 82 of Act 2 of 1974. Section 175 refers about omission to produce documents to public servants by person legally bound to produce it. Section 126 refers about omission to give notice or information to public servants by person legally bound to give it. Section 127 refers about furnishing false information. 171(8) refers about refusing oath or affirmation when duly required by public servant to make it. Section 179 refers about refusing to answer public servants authorized to question. Section 188 refers about refusing to sign statement. Section 181 refers about false statement on oath or affirmation to public servants or person authorized to administer an oath or affirmation. Section 182 refers about false information with intent to cause public servant to use his lawful power to the injury of another person. Section 183 refers about resistance to the taking of property by the lawful authorities of a public servants. Section 184 refers about obstructing sale of property offered for sale by authority of public servants. Section 185 refers about illegal purchase or bid for property offered for sale by authority of public servants. Section 186 refers about obstructing public servants in discharge of public functions. Section 187 refers about omission to assist public servants when bound by law to give assistance. Section 188 refers about disobedience to order duly promulgated by public servants. Section 189 refers about threat of injury to public servants. Section 190 refers about threat of injury to induce person to refrain from applying for protection to public servants. Chapter 11 of false evidence and offences against public justice. 191 refers about giving false evidence. Section 192 refers about fabricating false evidence. Section 193 refers about punishment for false evidence. Section 194 refers about giving or fabricating false evidence with intent to procure conviction of capital offence, if innocent person be thereby convicted and executed. Section 195 refers about giving or fabricating false evidence with intent to procure conviction of offence punishable with imprisonment for life or imprisonment. Section 195A refers about threatening any person to give false evidence. Section 196 refers about using evidence known to be false. Section 197 refers about issuing or signing false certificates. Section 198 refers about using as true a certificate known to be false. Section 199 refers about false statement made in declaration which is by law receivable as evidence. Section 200 refers about using as true such declaration knowing it to be false. Section 201 tells about causing disappearance of evidence of offense or giving false information to screen offender if a capital offense, if punishable with imprisonment for life, if punishable with less than 10 years imprisonment. Section 202 refers about intentional omission to give information of offense by person bound to inform. Section 203 refers about giving false information respecting an offense committed. Section 204 refers about destruction of documents to prevent its production as evidence, and this section is certainly applied in my case because my evidences were intently omitted and deleted from this device by those persons who wanted to manipulate the procedure. Section 205 refers about false personation for purpose of act or proceedings in suit or persecution. Section 206 refers about fraudulent removal or concealment of property to prevent its seizure as forfeited or in execution. Section 207 refers about fraudulent claim to property to prevent its seizure as forfeited or in execution. Section 208 refers about fraudulently suffering decree for sum not due. Section 209 refers about dishonestly making false claim in court. Section 210 refers about fraudulently obtaining decree for sum not due. Section 211 false charge of offense made with intent to injure. Section 212 refers about harboring offender if a capital offense, if punishable with imprisonment for life or with imprisonment. Section 213 refers about taking gift, etc. to screen an offender from punishment if a capital offense, if punishable with imprisonment for life or with imprisonment. Section 214 refers about offering gift or restoration of property in consideration of screening offender if a capital offense, if punishable with imprisonment for life or with imprisonment. Section 215 refers about taking gift to help to recover stolen property, etc. Section 216 refers about harboring offender who has escaped from custody of whose apprehension has been ordered if a capital offense, if punishable with imprisonment for life or with imprisonment. Section 216A refers about penalty for harboring robbers or dacoits. Because my property are being stolen, being robbed, then this section will also be implied. Section 216B was repealed. Section 217 refers about public servants disobeying direction of law with intent to save person from punishment or property from forfeiture. Section 218 refers about public servant framing incorrect record or writing with intent to save person from punishment or property from forfeiture. Section 219 refers about public servant in judicial proceedings corruptly making reports, etc., contrary to law. Section 220 refers about commitment for trial or confinement by person having authority who knows that he is acting contrary to law. Section 221 refers about intentional omission to apprehend on the part of public servants bound to apprehend. Section 222 refers about intentional omission to apprehend on the part of public servants bound to apprehend person under sentence or lawfully committed. Section 223 refers about escape from confinement or custody negligently suffered by public servants. Section 224 refers about resistance or obstruction by a person to his lawful apprehension. Section 225 refers about resistance or obstruction to lawful apprehension of another person. Section 225A refers about omission to apprehend or sufferance of escape on part of public servants in cases not otherwise provided for. Section 225B refers about resistance or obstruction to lawful apprehension or escape or rescue in cases not otherwise provided for. Section 226 refers about repeal. It was repealed. Section 227 refers about violations of condition of remission of punishment. Section 228 refers about intentional insult or interruption to public servants sitting in judicial proceedings. Section 228A refers about disclosure of identity of the victims of certain offences, etc. Section 229 refers about personation of a juror or assessor. Section 229A refers about failure by a person released on bail or bond to appear in court. Chapter 12 refers about of offences relating to coin and government stamps. Section 230 refers about coin defined Indian coin. Section 231 refers about counterfeiting coin. 232 about counterfeiting Indian coin. 233 about making or selling instrument for counterfeiting coin. Section 234 refers about making or selling instrument for counterfeiting Indian coin. Section 235 refers about possession of instrument or material for the purpose of using the same for counterfeiting coin if Indian coin. Section 236 refers about abating in India the counterfeiting out of Indian of coin. Section 237 refers about import or export of counterfeit coin. Section 238 import or export of counterfeit of the Indian coin. Section 239 refers about delivery of coin possessed with knowledge that it is counterfeit. Section 240 refers about delivery of Indian coin possessed with knowledge that it is counterfeit. Section 241 refers about delivery of coin as genuine, which when first possessed, the deliverer did not know to be counterfeit. 242 refers about possession of counterfeit coin by person who knew it to be counterfeit when he became possessed thereof. Section 243 refers about possession of Indian coin by person who knew it to be counterfeit when he became possessed thereof. 244 refers about person employed in mint causing coin to be of different weight or composition from that fixed by law. Section 245 refers about unlawfully taking coining instruments from mint. Section 246 refers about fraudulently or dishonestly diminishing weight or altering composition of coin. 247 about fraudulently or dishonestly diminishing weight or altering composition of Indian coin. Section 248 about altering appearance of coin with intent that it shall pass as coin of different description. Section 249 refers about altering appearance of Indian coin with intent that it shall pass as coin of different description. Section 250 refers about delivery of coin possessed with knowledge that it is altered. Section 251 refers about delivery of Indian coin possessed with knowledge that it is altered. Section 252 refers about possession of coin by person who knew it to be altered when he became possessed thereof. Section 253 refers about possession of Indian coin by person who knew it to be altered when has become possessed thereof. Section 254 refers delivery of coin as genuine, which when first possessed, the deliverer did not know to be altered. Section 255 refers about counterfeiting government stamps. 256 refers about having possession of instruments or material for counterfeiting government stamps. 257 refers about making or selling instrument for counterfeiting government stamps. 258 refers about sale of counterfeit government stamp. 259 refers having possession of counterfeit government stamp. 260 using as genuine a government stamp known to be counterfeit. 261 refers effacing writing from substance bearing government stamp or removing from document a stamp used for it, which with intent to cause loss to government. Section 262 refers using government stamp known to have been before used. 263 refers about erasure of mark denoting that stamp has been used. 263A refers about prohibition of fictitious stamps. Chapter 13 tells about of offences relating to weights and measures. 264 refers about fraudulent use of false instruments for weighting. 265 refers about fraudulent use of false weight or measure. 266 refers about being in possession of false weight or measure. 267 refers about making or selling false weight or measure. Chapter 14 tells about of offences affecting the public health, safety, convenience, decency and morals. 268 refers about public nuisance. 269 about negligence act likely to spread infection of disease dangerous to life. 270 refers about malignant act likely to spread infection of disease dangerous to life. 271 refers about disobedience to quarantine rule. 272 refers about adulteration of food or drink intended for sale. 273 refers about sale of noxious food or drink. 274 about adulteration of drugs. Section 275 refers about sale of adulterated drugs. 276 about sale of drugs as a different drug or preparation. 277 refers about faulting water, a public spring or reservoir. Section 278 refers about making it atmosphere noxious to health. Section 279 refers about rash driving or riding on a public way. Section 280 refers about rash navigation of vessel. Section 281 about exhibition of false light, mark or buoy. Section 282 refers about conveying person by water for hire in unsafe or overloaded vessel. Section 283 refers about danger of or obstruction in public way or line of navigation. Section 284 refers about negligent conduct with respect to poisonous substance. Section 285 refers about negligent conduct with respect to fire or combustible matter. Section 286 refers about negligent conduct with respect to explosive substance. Section 287 refers about negligent conduct with respect to machinery. Section 288 refers about negligent conduct with respect to pulling down or repairing building. Section 289 refers about negligent conduct with respect to animal. Section 290 refers about punishment for public nuisance in cases not otherwise provided for. Section 291 refers about continuance of nuisance after injunction to discontinue. Section 292 about sale, etc. of obscene books, etc. Section 293 about sale, etc. of obscene objects to young person. Section 294 refers about obscene acts and songs. 294A about keeping lottery office. Chapter 15 of offences relating to religion. Section 295 refers about injuring or defeating place of worship with intent to insult the religion of any class. 295A refers about deliberate and malicious acts intended to outrage religious feelings of any class by insulting its religion or religious beliefs. Section 296 refers about disturbing religious assembly. Section 297 about trespassing on burial places, etc. Section 298 refers about uttering words, etc. with deliberate intent to wound the religious feelings. Chapter 16 of offences affecting the human body. Of offences affecting life. Section 299 culpable homicide. 300 murder when culpable homicide is not murder. Section 301 refers about culpable homicide by causing death of person other than person whose death was intended. Section 302 about punishment for murder. Section 303 about punishment for murder by a life convict. Section 304 by punishment for culpable homicide not amounting to murder. Section 304A refers about causing death by negligence. Section 304B about dowry death. Section 305 about abatement of suicide of child or innocent person. Section 306 about abatement of suicide. Section 307 refers about attempt to murder, attempts by life convicts. Section 308 refers about attempts to commit culpable homicide. 309 about attempt to commit suicide. Section 310 about thug. 311 about punishment of the causing of miscarriage, of injuries to unborn children, of the exposure of infants, and of the concealment of births. Section 312 refers about causing miscarriage. 313 about causing miscarriage without woman's consent. 314 refers about death caused by act done with intent to cause miscarriage, if act done without woman's consent. Section 315 refers about act done with intent to prevent child being born alive or to cause it to die after birth. Section 316 refers about causing death of quick unborn child by act amounting to culpable homicide. Section 317 refers about exposure and abandonment of child under 12 years by parent or person having care of it. Section 318 refers about concealment of birth by secret disposal of dead body of hurt. Section 319 refers about hurt. 320 about grievous hurt. 321 refers about voluntarily causing hurt. Section 322 refers about voluntarily causing grievous hurt. Section 323 about punishment for voluntarily causing hurt. Section 324 for voluntarily causing hurt by dangerous weapons or means. Section 325 about punishment for voluntarily causing grievous hurt. Section 326 about voluntarily causing grievous hurt by dangerous weapons or means. Section 326A refers about voluntarily causing grievous hurt by use of acid, etc. Section 326B refers about voluntarily throwing or attempting to throw acid. Section 327 refers about voluntarily causing hurt to extort property or to constrain to an illegal act. This section is also implied. Section 328 refers about causing hurt by means of poison, etc., with intent to commit an offense. Section 329 refers about voluntarily causing grievous hurt to extort property or to constrain to an illegal act. Section 330 refers about voluntarily causing hurt to extort confession or to compel restoration of property. Section 331 refers about voluntarily causing grievous hurt to extort confession or to compel restoration of property. Section 332 refers about voluntarily causing hurt to deter public servants from his duty. Section 333 about voluntarily causing grievous hurt to deter public servants from his duty. Section 334 about voluntarily causing hurt on provocation. Section 335 refers about voluntarily causing grievous hurt on provocation. Section 336 refers about act endangering life or personal safety of others. Section 337 refers about causing hurt by act endangering life or personal safety of others. Section 338 refers about causing grievous hurt by act endangering life or personal safety of others, of wrongful restraint and wrongful confinement. Section 339 refers about wrongful restraint. 340 refers about wrongful confinement. Section 341 refers about punishment for wrongful restraints. Section 342 refers about punishment for wrongful confinement. Section 343 about wrongful confinement for 3 or more days. Section 344 refers about wrongful confinement for 10 or more days. Section 345 for wrongful confinement of person for whose liberation writ has been issued. Section 346 refers about wrongful confinement in secret. Section 347 refers about wrongful confinement to extort property or constraint to illegal act. Section 348 refers about wrongful confinement to extort confession or compel restoration of property of criminal forces and assaults. Section 349 refers about force. Section 350 refers about criminal force. Section 351 refers about assault. Section 352 refers about punishment for assault or criminal force otherwise than one on grave provocation. Section 353 about assault or criminal force to deter public servants from discharge of his duty. Section 354 refers about assault of criminal force to women with intent to outrage her modesty. Section 354A refers about sexual harassment and punishment for sexual harassment. Section 354B refers about assault or use of criminal force to women with intent to disrobe. Section 354C refers about voyeurism. Section 354D about stalking. Section 355 about assault or criminal force with intent to dishonor person otherwise than on grave provocation. Section 356 about assault or criminal force in attempt to commit theft of property carried by a person. Section 357 refers about assault or criminal force in attempt wrongfully to confine a person. Section 358 refers about assault or criminal force on grave provocation. Then of kidnapping, abduction, slavery and forced labor. Section 359 refers about kidnapping. 360 about kidnapping from India. 361 refers about kidnapping from lawful guardianship. Section 362 refers about abduction. 363 refers about punishment for kidnapping. Section 363A about kidnapping or maiming a minor for purpose of begging. 364 about kidnapping or abducting in order to murder. Then sections 364A refers about kidnapping for ransom, etc. 365 about kidnapping or abducting with intent, secretly and wrongfully to confine person. Section 366 refers about kidnapping, abducting or inducing women to compel her marriage, etc. Section 366A refers about procuration of minor girl. 366B refers about importation of girl from foreign country. Section 367 refers about kidnapping or abducting in order to subject person to grievous hurt, slavery, etc. Section 368 refers about wrongfully concealing or keeping in confinement, kidnapping or abducted person. Section 369 refers about kidnapping or abducting child under 10 years with intent to steal from its person. Section 370 refers about trafficking of person. 370A about exploitation of a trafficked person. Section 371 refers about habitual dealing in slaves. Section 372 about stealing minor for purpose of prostitution, etc. Section 373 refers about bullying minor for purpose of prostitution, etc. Section 374 refers about unlawful compulsory labor. Then about sexual offences, 375 refers about rape. Section 376 refers about punishment for rape. Section 376A about punishment for causing death or resulting in persistent vegetative state of victim. Section 376AB about punishment for rape on women under 12 years of age. Section 376B about sexual intercourse by husband upon his wife during separation. Section 376A refers about sexual intercourse by a person in authority. Section 376D refers about gang rape. Section 376DA refers about punishment for gang rape on women under 16 years of age. Section 376DB about punishment for gang rape on women under 12 years of age. Section 376E refers about punishment for repeat offenders of unnatural offences. Section 377 refers about unnatural offences. Then Chapter 17 of offences against property or theft. Section 378 will be implied with reference of theft. That is my theft away or theft. 379 refers about punishment for theft. 380 theft in dwelling house, etc. Section 381 refers about theft by clerk or servant of property in possession of master. Section 382 refers about theft after preparation made for causing death, hurt or restraint in order to the committing of the theft of extortion. Section 383 refers about extortion. 384 about punishment for extortion. 385 refers about putting person in fear of injury in order to commit extortion. Section 386 refers about extortion by putting a person in fear of death on grievous hurt. Section 387 refers about putting person in fear of death or of grievous hurt in order to commit extortion. Section 388 refers about extortion by threat of accusation of an offence punishable with death or imprisonment of life for life, etc. Section 389 refers about putting person in fear of accusation of offence in order to commit extortion, of robbery and dacoity. Section 390 refers about robbery when theft is robbery, when extortion is robbery. Section 391 refers about dacoity. 392 about punishment for robbery. Section 393 refers about attempt to commit robbery. Section 394 refers about voluntarily causing hurt in committing robbery. Section 395 refers about punishment for dacoity. Section 396 for dacoity with murder. Section 397 robbery or dacoity with attempt to cause death or grievous hurt. Section 398 will be implied with reference to attempt to commit robbery or dacoity when armed with deadly weapons. Section 399 making preparation to commit dacoity. Section 400 for punishment for belonging to gang of dacoits. Section 401 about punishment for belonging to gang of thieves. Section 402 will be applied for assembling for purpose of committing dacoity. Of criminal misappropriation of property. Section 403 will be applied for dishonest misappropriation of property. Section 404 for dishonest misappropriation of property possessed by deceased person at the time of his death. Of criminal breach of trust. Section 405 will be applied for criminal breach of trust. 406 for punishment for criminal breach of trust. Section 407 for criminal breach of trust by carrier, etc. Section 408 for criminal breach of trust by clerk or servants. Section 409 will be applied for criminal breach of trust by public servants or by banker, merchants or agents of the receiving of stolen property. Section 410 will be applied for stolen property. 411 for dishonestly receiving stolen property. Section 412 for dishonestly receiving property stolen in the commission of dacoity. Section 413 for habitually dealing in a stolen property. Section 414 deals about assisting in concealment of stolen property, then of cheating. Section 415 refers about cheating. 416 about cheating by personation. 417 by punishment for cheating. Section 418 for cheating with knowledge that wrongful loss may ensue to person whose interest offender is bound to protect. Section 419 for punishment for cheating by personation. 420 for cheating and dishonestly inducing delivery of property. Of fraudulent deeds and dispositions of property. Section 421 refers about dishonest or fraudulent removal of concealment of property to prevent distribution among creditors. Section 422 refers about dishonestly or fraudulently preventing debt being available for creditors. Section 423 refers about dishonest or fraudulent execution of deed of transfer containing false statement of consideration. Section 424 refers about dishonest or fraudulent removal or concealment of property of mischief. Section 425 will be applied in case of mischief. 426 for punishment for mischief. 427 for mischief causing damage to the amount of 50 rupees. Even if amount of 50 rupees is being damaged, then section 427 is applicable. What if in case of like abduction or damage of properties, intellectual property, worth of billions of rupees, billions of dollars? The organized criminals are working to accomplish their own goal by harming me. Section 428 will be applied in case of mischief by killing or maiming animals of the value of 10 rupees. 429 for mischief by killing or maiming cattle, etc. of any value or any animal of the value of 50 rupees. Section 430 for mischief by injury to works of irrigation or by wrongfully diverting water. Section 431 for mischief by injury to public road, bridge, river or channel. Section 432 for mischief by causing inundation or obstruction to public drainage attended with damage. Section 433 for mischief by destroying, moving or rendering less useful a lighthouse or sea mart. Section 434 for mischief by destroying or moving, etc. a landmark fixed by public authority. Section 435 for mischief by fire or explosive substance with intent to cause damage to amount of 100 or in case of agriculture produce 10 rupees. Section 436 for mischief by fire or explosive substance with intent to destroy house, etc. Section 437 for mischief with intent to destroy or make unsafe a decked vessel or one of 20 tons burden. Section 438 for punishment for the mischief described in Section 437 committed by fire or explosive substance. 439 for punishment for intentionally running vessel aground or ashore with intent to commit theft, etc. Section 440 for mischief committed after preparation made for causing death or hurt of criminal trespass. Section 441 for criminal trespass. 442 for house trespass. 443 for lurking house trespass. 444 for lurking house trespass by night. 445 house breaking. 446 house breaking by night. 447 punishment for criminal trespass. 448 for punishment for house trespass. 449 for house trespass in order to commit offence punishable with death. Section 450 for house trespass in order to commit offence punishable with imprisonment for life. Section 451 for house trespass in order to commit offence punishable with imprisonment. Section 452 refers about house trespass after preparation for hurt, assault or wrongful restraint. 453 for punishment for lurking house trespass or house breaking. 454 for lurking house trespass or house breaking in order to commit offence punishable with imprisonment. Section 455 for lurking house trespass or house breaking after preparation for hurt, assault or wrongful restraint. Section 456 for punishment for lurking house trespass or house breaking by night. Section 457 will be applied for lurking house trespass or house breaking by night in order to commit offence punishable with imprisonment. Section 458 will be applied in case of lurking house trespass or house breaking by night after preparation for hurt, assault or wrongful restraint. Section 459 for grievous hurt caused whilst committing lurking house trespass or house breaking. Section 460 will be applied for all persons jointly concerned in lurking house trespass or house breaking by night, punishable by death or grievous hurt caused by one of them. Section 461 will be applied for dishonestly breaking open receptacle containing property. Section 462 for punishment for same offence when committed by person entrusted with custody. Chapter 18 refers about of offences relating to documents and to property marks. 463 for forgery. 464 for making a false document. Section 465 for punishment for forgery. Section 466 for forgery of record of court or of public register, etc. Section 467 for forgery of valuable security, will, etc. Section 468 for forgery for purpose of cheating. Section 469 for forgery for purpose of harming reputation. 470 for forged documents. Section 471 for using a genuine forged document or electronic records. Section 472 for making a or possessing counterfeit, seal, etc. with intent to commit forgery, punishable under Section 467. Section 473 for making or possessing counterfeit, seal, etc. with intent to commit forgery, punishable otherwise. Section 474 for having possession of document described in Section 466 or 467, knowing it to be forged and intending to use it as genuine. Section 475 for counterfeiting device or mark used for authenticating documents described in Section 467 or possessing counterfeit mark materials. Section 476 for counterfeiting device or mark used for authenticating documents other than those described in Section 467 or possessing counterfeit mark materials. Section 477 for fraudulent cancellation, destruction, etc. of will authority to adopt or valuable security. Section 477A for falsification of accounts. Then with reference to of property and other marks, Section 478 was repealed. 479 refers to property mark. 480 was repealed. Section 481 refers for using a false property mark. 482 for punishment for using a false property mark. Section 483 for counterfeiting a property mark used by another. 484 for counterfeiting a mark used by a public servant. Section 485 for making or possessing of any instrument for counterfeiting a property mark. Section 486 for selling goods marked with a counterfeit property mark. Section 487 for making a false mark upon any receptacle containing goods. Section 488 for punishment for making use of any such false marks. Section 489 for tampering with property mark with the intent to cause injury of currency notes and banknotes. Section 489A for counterfeiting currency notes or banknotes. 489B for using a genuine, forged or counterfeit currency notes or banknotes. Section 489C for possession of forged or counterfeit currency notes or banknotes. Section 489D for making or possessing instruments or materials for forging or counterfeiting currency notes or banknotes. Section 489E for making or using documents resembling currency notes or banknotes. Then Chapter 19 deals about of the criminal breach of contracts of service. 490 was repealed. 491 refers about breach of contract to attend on and supply wants of helpful person. 492 was repealed. Then Chapter 20. Section 493 refers about cohabitation caused by a man deceitfully inducing a belief of lawful marriage. Section 494 for marrying again during lifetime of husband or wife. Section 495 refers about same office with concealment of former marriage from person with whom subsequent marriage is contracted. Section 496 for marriage ceremony fraudulently gone through without lawful marriage. Section 497 for adultery. 498 for enticing or taking away or detaining with criminal intent a married woman. Chapter 21, 20A of cruelty by husband or relatives of husband. 498A refers about husband of relative of husband of a woman subjecting her to cruelty. Chapter 21 refers about of defamation. 499 about defamation, imputation of truth which public goods required to be made or published, public conduct of public servants, conduct of any person touching any public question, publication of reports of proceedings of courts, merits of case decided in court or conduct of witness and other concerned, merits of public performance, censure passed in good faith by person having lawful authority over another, accusation preferred in good faith to authorized person, imputation made in good faith by person for protection of his or other interest, caution intended for good or person to whom conveyed or for public goods. Section 500 for punishment for defamation. 501 for printing or engraving matter known to be defamatory. Section 502 will be applied to sale of printed or engraved substance containing defamatory matter. Chapter 22 refers about of criminal intimidation, insult and annoyance. Section 503 for criminal intimidation. 504 for intentional insult with intent to provoke breach of the peace. Section 505 for statements conducting to public mischief, statements creating or promoting enmity, hatred or ill will between classes. Offences under subsection 2 committed in place of worship, etc. Section 506 for punishment for criminal intimidation, if threats be the cause, death or grievous hurt, etc. Section 507 for criminal intimidation by an anonymous communication. Section 508 for act caused by inducing person to believe that he will be rendered an object of the divine displeasure. Section 509 for word, gesture or act intended to insult the modesty of a woman. Section 510 for misconduct in public by a drunken person. And Chapter 23 of attempts of commit offences. Section 511 refers about punishment for attempting to commit offences, punishable with imprisonment for life or other imprisonments. And the Indian Penal Code continues. Like Act number 45 of 1860s, it was published on 6th October 1860s, Chapter 1 about introduction. Preamble tells that whereas it is expedient to provide a general penal code for India, it is enacted as follows. Pehla, title and extent of operation of the code. This act shall be called the Indian Penal Code and shall extend to the whole of India. 2. Punishment of offences committed within India. Every person shall be liable to punishment under this code and not otherwise for every act or omission contrary to the provisions thereof of which he shall be guilty within India. 3. Punishment of offences committed beyond but which by law may be tried within India. Any person liable by any Indian law to be tried for an offence committed beyond India shall be dealt with according to the provisions of this code for any act committed beyond India in the same manner as if such act had been committed within India. 4. Extension of code to extraterritorial offences. The provision of this code apply also to any offence committed by any citizen of India in any place without and beyond India. 2. Any person on any ship or aircraft registered in India wherever it may be. 3. Any person in any place without and beyond India committing offence targeting a computer resource located in India. Explanations in this section. A. The word offence includes every act committed outside India which, if committed in India, would be punishable under this code. First, the Indian Penal Code has been extended to bearer by the Bearer Law Acts 1941, 4 of 1941, and has been declared in force in Santhal Parganas by the Santhal Parganas Settlement Regulations Act 1872, 3 of 1872, Panth Piploda by the Panth Piploda Law Regulation 1929, 1 of 1929, Khandamals District by the Khandamals Law Regulations 1936, 4 of 1936, Angul District by the Angul Law Regulations 1936, 5th of 1936. It has been declared under Section 3A of Scheduled Districts Acts 1874, 14 of 1874, to be in force in the following scheduled districts, namely the United Province Tarai districts. See Gazette of India 1876. Then the district of Hazaribagh, Lohatagga, now called the Ranchi districts, Calcutta Gazette 1899, and Manbhum and Pargana Dalbhum and Kollam in the district of Singhbhum, Gazette of India 1881. It has been extended under Section 5 of same Act to the Lusai Hills. See Gazette of India 1898. The Act has been extended to Goa, Daman and Diu by Registration 12 of 1962, Section 3, and Sage to Dadar and Nagar Haveli by Reg 6 of 1963, Section 2 and Section 1 to Pondicherry by Reg 7 of 1963, Section 3 and Section 1 and 2 Lakshadweep by Reg 8 of 1965, Section 3 and Section. Dusra. The word British India have successively been subjects by the AO 1948 and the AO 1950 and the Act 3 of 1951, Section 3 and the Section 2 read as above. 3. The original words have successfully been amended by Act 12 of 1891, Section 2 and SCH 1 of the AO 1937 and AO 1948 and AO 1952 read as above. 4. The word except the state of Jammu and Kashmir omitted by Act 34 of 2019, S95 and the 5th schedules with effect from 31/10/2019. 5th, the original words the said territories have successfully been amended by AO 1937, the AO 1948, AO 1950 and Act 3 of 1951, S3 and the says to read as above. 6. The words and figures on or after the said first day of March 1861, repeated by Act 12 or 1891, S2 and the first 6. 7. Subject by the AO 1937 for law passed by Governor General of India in Council. 8. The original words, the limits of the said territories have successfully been amended by AO 1937, the AO 1948, the AO 1950 and Act 3 of 1951, S3 and CS to read as above. Then subsection by Act 4 of 1898, S2 for Section 4, 10 for subject by AO 1950 for clause 1 to 4, then 11 is about NS by Act 10 of 2009, S51 with effect from 27/10/2009, 12 about subsection by S51, IBID for the explanation with effect from 27/10/2009, and the expression computer resource shall have the meaning assigned to it in clause K of subsection I of the section 2 of the Information Technology Act 2021 of 2000. Then illustration. A refers about who is a citizen of India commits a murder in Uganda. He can be tried and convicted of murder in any place in India in which he may be found. 5. Certain law not to be affected by this act. Nothing in this act shall affect the provision of any act for punishing mutiny and discharging of officers, soldiers, sailors or airmen in the service of the Government of India, or the provisions of any special or local law. Chapter 2 refers about general explanations. 6. Definitions in the code to be understood subject to exceptions. Throughout this code, every definitions of an offence, every penal provisions, and every illustration of every such definition of penal provision provision shall be understood, subject to the exceptions contained in chapter entitled General Exceptions, through those exceptions are not repeated in such definition, penal provisions or illustrations. Illustrations A. The section in this code which contain definitions of offence do not express that a child under 7 years of age cannot commit such offence, but the definition are to be understood subject to the general exceptions which provides that nothing shall be an offence which is done by a child under 7 years of age. And B. A police officer without warrant apprehends Z who has committed murder. Here A is not guilty of the offence of wrongful confinement, for he was bound by law to apprehend Z, and therefore the case falls within the general exceptions, which provides that nothing is an offence which is done by a person who is bound by law to do it. 7. About sense of expression once explained. Every expression which is explained in any part of this code is used in every part of this code in conformity with the explanation. 8 refers about gender. The pronouns he and its derivatives are used of any person, wherever male or female. 9 about number. Unless the contrary appears from the context, words importing the singular number includes the plural number, and words importing the plural number includes the singular number. 10 about man or woman. The word man denotes a male human being of any age. The word woman denotes a female human being of any age. 11 about person. The word person includes any company or associations or body of person, whenever incorporated or not. 12 about public. The word public includes any class of the public or any community. Section 13 about definition of queen, omitted by AO 1950. Section 14 about servants of governments. The word servants of governments denote any officer or servant continued, appointed or employed in India by or under the authority of government. Section 15 about definition of British India, represented by the AO 1937. Section about definition of Government of India, represented IBID. And these are the footnotes associated with the explanation. Then 17 about government. The word government denotes the central government or the government of state. 18 about India. India means the territory of India, excluding the state of Jammu and Kashmir. 19 about judge. The word judge denotes not only every person who is officially designated as a judge, but also every person who is empowered by law to give in any legal proceedings, civil or criminal, a definitive judgment, or a judgment which is, if not appealed against, would be definitive, or a judgment which, if confirmed by some other authority, would be definitive, or who is only a body of person, which body or person is empowered by law to give such a judgment. The illustrations, like a collector exercising jurisdiction in a seat under Act 10 of 1859 is a judge. B. A magistrate exercising jurisdiction in respect of a charge on which he has power to sentence to fine or imprisonment with or without appeal is a judge. C. A member of a panchayat which has power under Regulation 7, 1816 of the Madras Court to try and determine suits is a judge. D. A magistrate exercising jurisdiction in respect of a charge on which he has power only to commit for trial to another court is not a judge. 20. Court of Justice. The words Court of Justice denote a judge who is empowered by law to any act judicially alone, or by a body of judge which is empowered by law to act judicially as a body, when such judge or body of judge is acting judicially. Then illustrations are given. Like a panchayat acting under Regulation 7, 1816 of the Madras Court, having power to try and determine suits, is a court of justice. 21. Public servants. The word public servants denotes a person falling under any of the descriptions hereinafter following, namely, second, every commissioned officer in the military, naval or air forces of India. Third, every judge, including any person empowered by law to discharge whenever by himself or a member of any body of a person any adjudicatory functions. D. Fourth, every officer of a court of justice, including a liquidator, receiver, or commissioner, whose duty it is as such officer to investigate or report on any matter of law or fact, or to make authentic or keep any documents, or to take charge or dispose of any property, or to execute any judicial process, or to administer any oath, or to interpret, or to preserve order in the court, and every person specially authorized by a court of justice to perform any of such duties. Fifth, every juryman, assessor, or member of a panchayat assisting a court of justice or public servants. 6. Every arbitrator or other person to whom any cause or matter has been referred for decision or report by any courts of justice or by any other competent public authority. These are the footnotes. Then 7th, every person who holds any office by virtue of which he is empowered to place or keep any person in confinement. 8. Every officer of the government whose duty it is as such officer to prevent offences, to give information of offence, or to bring offenders to justice, or to protect the public health, safety, and convenience. 9th, every officer whose duty it is as such officer to take, receive, keep, or expend any property on behalf of the government, or to make any survey, assessment, or contract on behalf of the government, or to execute any revenue process, or to investigate or to report on any matter affecting the pecuniary interest of the government, or to make, authenticate, or keep any documents relating to the pecuniary interest of the government, or to prevent the infraction of any law for the protection of the pecuniary interest of the government. 10th, every officer whose duty it is as such officer to take, receive, keep, or expend any property, to make any survey or assessment, or to levy any rate or tax for any secular common purpose of any village, town, or district, or to make, authenticate, or keep any documents for the ascertaining of the rights of the people of any village, town, or district. 11th, about every person who holds any office in virtue of which he is empowered to prepare, publish, maintain, or revive an electoral roll, or to conduct an election or part of an election. 12, about every person A, in the service or pay of the government, or remunerated by fees or commissions for the performance of any public duty by the government. And B, in the service or pay of a local authority, a corporation established by or under a certain central, provincial, or state act, or a government company as defined in section 617 of the Companies Act 1956, 1 of 1956. Then illustrations. A municipal commissioner is a public servant. Explanation 1. Persons falling under any of the above descriptions are public servants, whenever appointed by the government or not. Explanation 2. Wherever the words public servants occur, they shall be understood of every person who is in actual possession of the situation of a public servant, whatever legal defect there may be in his rights to hold that situation. Explanation 3, about the word election, denotes an election for the purpose of selecting members of any legislative, municipal, or other public authority of whatever character the method of selection to which is by or under any law prescribed as by election. Then statement amendments, like the Rajasthan Amendment of Section 21 Central Act 45 of 86 in Section 21 of Indian Penal Code 1860, Central Act 45 of 1860. In its application to the state of Rajasthan, after clause 12, the following new clause shall be added, namely, like 13th, every person employed or engaged by any public body in the conduct and supervisor of any examination recognized or approved under any law. Then explanations. The expressions public body includes A. 1. A university, board, or education or other body either established by or under a central or state acts or under the provisions of the Constitution of India or constituted by the government, and B. A local authority. White Rajasthan Act 4 of 1993. 22. Movable property. The words movable property are intended to include corporeal property of every description, except land and things attached to the earth or permanently fastened to anything which is attached to the earth. 23 is wrongful gain. A wrongful gain is gained by unlawful means of property to which the person gaining is not legally entitled. Wrongful loss. Wrongful loss is the loss by unlawful means of property to which the person losing it is legally entitled. Gaining wrongfully or losing wrongfully. A person is said to gain wrongfully when such person retains wrongfully, as well as when such person acquires wrongfully. A person is said to lose wrongfully when such person is wrongfully kept out of any property, as well as when such person is wrongfully deprived of property. 24 about dishonestly. Whoever does anything with the intention of causing wrongful gain to one person or wrongful loss to another person is said to do that things dishonestly. 25 for fraudulently. A person is said to be do a thing fraudulently if he does that thing with intent to defraud, but not otherwise. 27 refers about reason to believe. A person is said to have reason to believe a thing if he has sufficient cause to believe that things, but not otherwise. 27 refers about property in possession of wife, clerk, or servant. When property is in the possession of a person's wife, clerk, or servants, or accounts of that person, it is in that person's possessions within the meaning of his code. Explanations. A person employed temporarily or on a particular occasion in the capacity of a clerk or servant is a clerk or servant within the meaning of this section. 28 about counterfeit. A person is said to counterfeit who causes one thing to resemble another thing, intending by means of that resemblance to practice deception, or knowing it to be likely that deception will thereby be practiced. Explanation 1. It is not essential to counterfeit that the limitation should be exact. Explanation 2. When a person causes one thing to resemble another thing, and the resemblance is such that a person might be deceived thereby, it shall be presumed until the contrary is proved that the person so causing the one thing to resemble the other thing intended by means of that resemblance to practice deception, or knew it to be likely that deception would thereby be practiced. Section 29 refers about documents. The word documents denotes any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means intended to be used or which may be used as evidence of that matter. Explanation 1. It is immaterial by what means or upon what substance the letter, figures, or marks are formed, or whether the evidence is intended for or may be used in a court of justice or not. Illustrations. Writing expressing the terms of contract which may be used as evidence of the contract is a document. A check upon a banker is a document. A power of attorney is a document. A map or plan which is intended to be used or which may be used as evidence is a document. Writing containing directions or instructions is a document. Then explanation 2. Whatever is expressed by means of letters, figures, or marks as explained by mercantile or other usage shall be deemed to be expressed by such letters, figures, or marks within the meaning of this section, although the same may not be actually expressed. Illustrations. A writer's his name on the back of a bill or exchange payable to his order, the meaning of the endorsements as explained by mercantile usage is that the bill is to be paid to the holder. The endorsement is a document and must be constructed in the same manner as if the words pay to the holder or words to the effect has been written over the signature. 29A refers about electronic records. The words electronic records shall have the meaning assigned to them in clause T of subsection 1 of section 2 of the Information Technology Act 2021 of 2000. Then 30 about valuable security. The words valuable security denotes a document which is or purports to be a document whereby any legal right is created, extended, transferred, restricted, extinguished, or released, or whereby any person acknowledges that he lies under legal liability or has not certain legal rights. Illustrations or its his name on the back of a bill or exchange, as the effect of the endorsement is to transfer the right or to the bill to any person who may become the unlawful holder of it. The endorsement is a valuable security. 31. A will. The words a will denotes any testamentary documents. 32. About words referring to X includes illegal omissions in every part of this code except where a contrary intention appears from the context. Words which refer to X then extend also to illegal omissions. Section 33. Acts omission. The word X denotes as well as series of X as a single act. The word omission denotes as well as series of omission as a single omission. 34. About acts done by several persons in furtherance of common intention. When a criminal act is done by several persons in furtherance of the common intention of all, each of such person is liable for that act in the same manner as if it were done by him alone. 35. About when such an act is criminal by reason of its being done with a criminal knowledge or intention. Whenever an act which is criminal only by reason of its being done with a criminal knowledge or intention is done by several persons, each of such person who joins in the act with such knowledge or intention is liable for the act in the same manner as if the act were done by him along with that knowledge of intention. 36. Refers about effect caused partially by act and partially by omission. Whenever the causing of a certain effect or an attempt to cause that effect by an act or by an omission is an offense, it is to be understood that the causing of that effect partially by an act and partially by an omission is the same offense. Then illustrations are given like intentionally causes Z's death partially by illegally omitting to give Z food and partially by beating Z. A has committed murder. 37. About a cooperation by doing one of several acts constituting an offense. When an offense is committed by means of several acts, whoever intentionally cooperates in that commission of that offense by doing any one of those acts, either singly or jointly with any other person, commits that offense. Illustrations: A and B agree to murder Z by severally and at different times, giving him small doses of poison. A and B administered the poison according to the agreement with intent to murder Z. Z dies from that effects. There are several doses of poison so administered to him. Here A and B intentionally cooperates in the commissions of murder and each of them does an act by which the death is caused. They are both guilty of the offense through their act are separate. B. A and B are joint jailers and as such have the charge of Z, a prisoner, alternatively for 6 hours at a time. A and B, intending to cause Z's death, knowingly cooperate in causing that effect by illegally omitting H during the time of his attendance to furnish Z with food supplied to them for that purpose. Z dies of hunger. Both A and B are guilty of the murder of Z. C. A jailer has the charge of Z, a prisoner. A, intending to cause Z's death, illegally omits to supply Z with food, in consequences of which Z is much reduced in strength, but though starvation is not sufficient to cause his death, A is dismissed from his office and B succeeds him. B. Without collision or cooperation with A, illegally omits to supply Z with food, knowing that he is likely that thereby to cause Z's death, Z dies of hunger. B is guilty of murder, but as A did not cooperate with B, A is guilty only of an attempt to commit murder. 38 refers about persons concerned in criminal act may be guilty of different offences. Whenever several persons are engaged or concerned in the commission of a criminal act, they may be guilty of different offences by means of that act. Like illustrations, A attacked Z under such circumstances of grave provocation that his killing of Z would be only culpable homicide, not amounting to murder. B. Having ill will towards Z and intending to kill him, and not having been subject to the provocation, assist A in killing Z. Here, though A and B are both engaged in causing Z's death, B is guilty of murder, and A is guilty only of culpable homicide. 39 about voluntarily. A person is said to cause an effect voluntarily when he causes it by means whereby he intended to cause it, or by means which at the time of employing those means he knew or had reason to believe it to be likely to cause it. It will continue later. I will continue it later. This is the first part of this, and the journey will continue. I will complete this presentation further.